and gentlemen, a very warm welcome to this prestigious event that is at the crossroads of legal excellence and innovation. Forbes India presents Legal Powerlist 2022 Summit and Awards. I'm Swati Shahi. This is in association with Legit Quest. In a sense, our panel discussion will now share as a compass. In fact, it will serve as a compass guiding us through the intricate maze of taxation, both global and domestic. And to conduct the session, I invite on stage my colleague Ashmit and our esteemed panelists to join him.
Thank you so much for being a part of this conversation. Let's begin first with an opening remark about what you believe should be the agenda going forward and what should dictate the conversations going forward. Mr. Kant, I'll come to you first.
Well, as far as taxation is concerned, we have lot many challenges still, although GST has been implemented, and on the direct tax front, government is working upon various measures to actually tax the digital economy, and the entire world is grappling with that. So we can take up that as an issue.
Ms. Bhatia, your opening thoughts, in your experience, what are some of the challenges that you've seen which you think need some addressing going forward?
With the introduction of the old and the new regime of tax in the direct tax perspective, there has been a lot of welcoming changes introduced by the finance minister. But however, there had been some challenges in implementation because not everyone can go for the implementation for the new regime.
That's interesting. In fact, that's one conversation I can take back to my HR department as well. Dr. Sharma, thank you for being a part of this. I remember you were there in the last edition as well. Between the last time and now, the changes that you've seen, opening remarks that you think, some of the issues that have come to light.
So, as far as GST is concerned, GST is a subsumization of 17 type of indirect taxes, as we all know. But there are still challenges businesses are facing in terms of input tax credit, in terms of HSN classification, or in terms of dual GST system where state and center officers both have power to take cases. I can see in many cases like businesses getting notice from center and the state on the similar subject matter. However, there is a law that one cannot supersede the other who has already given notice on that, but still there are chaotic situations where businesses are getting notices. So these are some of the hurdles. Government is working very hard to resolve them as much as possible in the given time, but still there are issues, and we expect that these issues would be resolved sooner or later.
Mr. Jain, thank you so much. Just before this conversation started, you were giving us some insight as to what the tax implications are, what interpretational issues, how that translates into financial problems and financial issues. So just again, an opening remark just to set the agenda.
Sure. So as a finance professional, I would say that all costs are important, and especially when we look at infrastructure business wherein I am working, so the margins are pretty thin, so every cost matters to us. So any interpretation issue can wipe out entire, I would say, the returns on equity, which will then impact future investments, risks and everything. So that's why it's very important to have no interpretation issues, especially in roads infrastructure. I would say that there have been issues which have been pending for long, which we can discuss subsequently.
Ms. Bhatia, let me come to you first. You had spoken about some of the changes that we've seen on a personal tax front. I personally, a sense, number one, as to this change, how the implementation has been, or whether there are challenges that you faced in execution. And number two, is this regime here to stay?
Yeah, so interestingly, yes, the new regime has been the default option for all the taxpayers. However, we have the option to select and go back to the old tax regime based on what is our income and what is the standard the deductions that we can avail and the exemptions that we can avail. Unfortunately, in the new tax regime, you don't have many of exemptions apart from income from house property, only if it is let out. If you are self-occupied house property, you're bearing the interest for a house property which is basically your own or self-occupied, then you are not getting any exemption in the new tax regime. Also, there has been 70 exemptions given in the old tax regime. But however, in the new tax regime, there is no LTA, there is no HRA. So and not even 80C, 80D. So it's a very challenging in that perspective. However, this has been welcoming for people who are basically young and has come into the corporate world. They don't have any HRA to be claiming, and they have very less deductions because the government from 1st April 2023 in the budget has announced that in the new tax regime, if your salary is 7 lakh, then you don't have to pay any tax to the government. But that doesn't mean that you don't have to file the income tax return. You have to file it.
Mr. Kant, coming to you, again, in the spirit of keeping this forward-looking, one aspect, I think, from a taxation perspective that many I've seen tax experts deal with is taxation of digital economy. The question I want to ask you is, how do we tax it? We have large tech players here, operating here. How do we tax that? Because there is obviously income being gained from the operations here, but there are still question marks.
Well, explaining the issue in a bit more explained manner. So what is happening is that now no country actually can survive without having a digital economy operating in their entire economy. So earlier, when the tax laws were actually devised, they were having a concept of physical presence. So it was not conceptualized or contemplated at that time that any business would be able to operate even without having any kind of office or physical presence in any location. But nowadays, the technology has made all that possible. Now with this, the country wherein the customer is actually paying to get these digital services, the service provider is not having any presence physically. Still, they are an income, and the very concept of, or the principle of the service provider or the businesses should be paying taxes in the jurisdictions from which they are earning money. Sure. So this is based on that. And to deal with these issues, OECD actually came up with a draft, and they came up with BAPS principle, which is base erosion and profit shifting. And this is to deal with this practice and to come up with principles wherein these businesses where they are paying taxes in their resident country, they should be rather paying in their country of operations. So OECD has come up with this draft, and as a consultative paper was released, and hopefully by 2024 it should get implemented.
Let's talk about the physical economy. Mr. Jain, you shared some very interesting insights that looking at it from a financial perspective, you pointed out that with the current tax legislations and the current tax laws, there are so many interpretational issues. If you can describe this journey for us from interpretational issues to the financial impact that you experience in your work.
Sure. So I would say that NHA has been a forerunner in having all these triple P contracts. And initially, some of the foreign investors, they directly participated in EPC companies. And then came these SPVs under triple P contracts. And all the infra player wanted to participate in those SPV directly, wherein they can own almost 100% of the ownership of these SPVs. Now, 2-3 ways how an investor can participate. So one is, I would say, buying it from a already existing Indian player. Now, how it happens is that there are certain issues. For example, when it comes to direct tax, how do you charge depreciation on a road SPV? So the Income Tax Act says 25% intangible. There is a AY Circular 2014, which says that you have to charge it as a business expense, but it's not applicable on the user. It's applicable for the assessing officer. Now, this is one of the big interpretation issue. Now, how do I price it? See, if I'm planning to buy it from some already existing player, if I go and ask him, you bear the cost, he would say that why would I bear the cost? I am, say, running this company for last 5 years. Now, how do you work it out? Whether you will take indemnities, what do you do? Then taking indemnities is also a challenge because getting it executed is also a problem. So sometimes you feel that the deal value is probably 500 crores. The value of indemnity is running to be maybe around 800 crores because of say, all the issues in terms of tax, penalties, and everything. So these kind of issues happens when you do, say, deal directly with a third party. Other option how a foreign investor invests by participating in the asset monetization program. So NHI also, its assets, already constructed assets through TOT program.
The input tax credit, which is a very big issue in GST right now, and most of the litigations are in the market already. And as far as input tax credit is concerned, it has two impacts. One impact is the litigation expense. Second is the working capital blockage. So the burden of proving the legitimacy of the input tax credit is with the recipient. So now what law says? Law says that once the tax is paid within the government treasury, you can claim the input tax credit. But on the other side, there is no mechanism to check whether the tax is actually paid or just return is filed. We can only check whether return is filed or not. We cannot check whether tax is paid or not, or how much tax has been paid, whether whatever I have given to my supplier against the purchase I've made is being paid to the government or not. So that's a big challenge. And even if there is a mechanism, I can see government officers are catching the recipient first, rather than catching the supplier first who has collected the tax and enjoyed that tax on whatever collected on behalf of the government.
I'd like to thank all of our panelists here, Mr. Kant, Ms. Bhatia, Mr. Sachin, Mr. Jain. Thank you so much for being a part of this. And with that, we'd like to call an end to this panel discussion. Thank you so much.
Gentlemen, we now move on to our next discussion on crafting consensus, harnessing the power of arbitration and mediation. Through this conversation, we aim to focus on the potent tools of arbitration and mediation, which played pivotal roles in resolving corporate and commercial disputes. Our panel of experts will guide us through the essentials of arbitration and mediation, emphasizing their advantages in corporate and commercial matters. So without further ado, calling on stage Gunita Pava, Joint Managing Partner, SNA Law Offices, to moderate the session.
Good afternoon, everyone. So now that we are all seated and going to begin this discussion, I'm going to start with the most important recent development that we've seen just last week about the Mediation Act. And starting with you, sir, Mr. Hemant Kumar, what in your experience does the Mediation Act hold for the future of mediation in India, sir?
See, when I go through the recent Mediation Act, I'm very excited for 2-3 reasons, which you will also appreciate. Now, as per this Mediation Act, the most important thing is that once the mediation agreement is signed, that becomes binding, and it becomes just like a decree or judgment of the court. That is the very important, I think, change. Another important of Mediation Act is the challenge of that agreement is very limited. What are those grounds? Not like public policy or public interest or patently illegal.
We've all seen patent illegality, and we've seen how it's led to arbitration appeals.
Correct. It says that if there is a corruption, fraud, and it doesn't fall under 6, I will explain you differently. Only on this limited ground you can challenge that, that particular agreement, which is just like a degree. Another important aspect of this, that time period is very important. If you wish to challenge the mediation agreement, please note it within 90 days, and you may be given another 90 days of cushion. So 120 days. Provided you somehow say that ground, your allegation is that one of the ground is available.
So moving on to you, Mustafa, in your vast experience as far as a practicing lawyer, how do you feel the mediation is going to help or assist your clients in better resolution of disputes?
So I think mediation is already very prevalent in the country in different modes and different stages. One such successful mediation practice is under the Commercial Courts Act, under Section 12A, where if there is no urgent reliefs to be claimed by the plaintiff, then there has to be a compulsory mediation within a specified time frame. Personally, I have found this to be very successful in two of the matters which I have done recently, and the mediation was successful. The parties just need to come together, and the mediator plays a very important role. But that is about Section 12A of the, it is cost effective, it is time bound, and it is literally non-appealable and enforceable just as a decree of the court, which gives it real teeth to the legislation. And that is something which was really required, especially on the commercial dispute side.
I completely agree with you. If it was not made enforceable, clients would have hardly voluntarily taken up the time to spend on mediation and then go to dispute resolution. I think both of you have made very good points. Now, Mr. Satish, what according to you is going to be the applicability of mediation in the with the GCs and in commercial disputes?
Yeah, so mediation is very critical, and I think mediation is more voluntary. So I think it's going to have a lasting impact. If you can see that there are data points which states that 90% of the mediations are successful. Yeah. So that's a very good positive data point that are emerging. And with the act coming into force here, so since it's not a formal mechanism, but a voluntary mechanism, the success of mediation are very high. So in fact, I have seen that even in the corporate world, more than the arbitration or a litigation, it's the mediation which strikes. But because at the end, nobody wants to go to a litigation, you know. Nobody wants to burn their good money. So I think, so hence, you know, mediation is going to have a lasting impact, and we'll see more and more success of mediation. And corporates, especially the in-house counsels like me, will adopt mediation with open hands.
Okay, so the next topic, which is equally interesting, it's about making India an arbitration hub. What are the advantages and what are the challenges that we see in achieving that goal? So starting with you, Mr. Hemant Kumar, sir, what do you, in your experience, have to say?
Say if you are dealing with Chandrayaan, we are involved in Chandrayaan, we are involved in all power, defense, construction. With due respect, for 2, 3 days, 4 days, we struggle to explain the technology. Forget about the commercial terms and conditions. Technology. And I remember we are constructing coastal road in Mumbai. So 13 PILs were filed. And when it reached to the Supreme Court, how in India PIL is filed, everybody knows it. So I did not comment on that. So they thought that we will approach. Okay, so when it went to the Supreme Court, I personally persuaded my technology expert that let us make a 10 minutes video that what is coastal road, how it is constructed, how difficult it is. And when the matter was before the 3 CGI, first case was before Mr. Gogoi, then Bobde, then Mr. current sitting there. We have shown that what is this technology, coastal road, how it will go beyond the, sea. They have realized that all this PIL is nothing but nonsense, just to delay the project, and especially those who have 200 crores of flat at 301 flat. So my view is that it also depends the law firm and the in-house counsel that when you have a complex dispute, selection of your nominee arbiter, because on nominee arbitrator, you have a control.
Yes.
Whereas
Party
the
autonomy.
other side, yeah.
Yes.
So better you appoint a guy who has the expertise on that technology and commercial mindset, that is called business efficacy.
Now, Mustafa, to you, India as an arbitration hub, do you see it as a reality or you see the challenges more?
Because since the time the 1996 Act came into force, there have been several amendments which are very progressive, which is in alignment with the international arbitration regime. and the enforceability and the challenge to arbitration. So challenge has become difficult, enforceability has become easier. India being a part of the New York Convention, as we all know, the New York Convention and the UNCITRAL rules, that is applicable here. But India is also engaging in having reciprocal relationship with different countries, as a result of which an award passed in that country becomes easily enforceable in India as a decree of an Indian court. But that said, the latest amendments, that is, when I say latest, it's 2019, and there are some things which are still under scrutiny, and we have made our presentations and what needs to be done under the further amendments. We have a very robust mechanism.
Now to you, sir, how do you feel, or what do you feel that should be steps that should be taken to make India an arbitration hub?
I think alternate dispute resolution is a big step forward in India, especially when, litigation is taking long duration, civil litigation taking long duration. I think this time, at this juncture, India will certainly be a arbitration hub. There is no second thought to it. You see that in PSU or PSU banks or government organization, usually they prefer to appoint their own arbitrator. So, as an in-house counsel, you have a resistance to it, and usually the government clauses, such clauses are non-negotiable. You have to go with those clauses.
Great. I think we had a very, very enlightening discussion as far as I'm concerned, and I hope the rest of the people also enjoyed. Thank you so much, all of you.
Thank you very much.